can do it this way, and again, everybody will get the PowerPoint,
Right.
okay?
Yeah,
And
you
assume
you
you
have
pull
it.
up the
very well
PowerPoint for
together.
you on here.
Could you?
Yeah, cause you emailed it.
Yeah, I emailed it.
I love her, I mean, I
So if
like
you can pull it up, and then I would just
You
advance the
I
slides
have
so
a
you could.
really-
Do this.
Yeah, I'm gonna get it from
I
Kenya.
send her.
All right,
Yeah.
perfect.
Thank
All
you.
right, let me just make some more
Go
general
ahead. Yeah.
comments.
Or you just, or we just go from there. That's
And
fine.
then we go
I
from there.
just, yeah.
Okay, so,
I'm just gonna
as
go.
soon as we solve the technology, all right, so, the first point was that when I consult in this area around the world, the basic systems of law are the same, right? So, we want the kids to come out of childhood with bonded relationships with both parents, and deep enough that it will survive over a lifetime, because these relationships are built to last a lifetime. And far too often, the family law paradigm is, you know, oh, the child's 16, why would we bother, the child's old enough to decide, and then you say, old enough to decide to ditch a parent. You sure that's the value system inherent in the governing legislation? Because clearly it's not. And then when you look at the neuroscience in this area, there's a lot of research done in the overlap between neuroscience and what's going on with these teenagers and young adults. We know that the prefrontal cortex doesn't mature until 24 and a half. And so we have decisions like we don't let kids drink alcohol till 19, and there's graduated driver licensing. We know from 100 years of insurance statistics that accident rates fall off a cliff, pardon the pun, as soon as a young adult turns 25, and they have 100 years of driving data. Think about the implications of that for family law. There's something going on. The young adults' minds reach a point where they start to worry for the first time. They start to focus on the future for the first time. The potential sense of loss can overwhelm the excitement of new experiences. So there's this transformation at 24, 25, where you can start to think in a different way. But the family law system is somehow premised on, you know, we lose jurisdiction at 18, so are we gonna try at 17? Are we gonna try at 16? Are we gonna try at 15? You have parents starting to program the kids, you know, at 12 you can decide. Like, they're 9 years old and they're already grooming them to ditch the other parent. So there's a fundamental flaw there. So we have that challenge in all jurisdictions, Canada included, even though, Joel, I don't know whether you were in the room, but I was describing to people why in Canada we have by far the most robust body of jurisprudence in this area. And it's by far, and I've studied the legal systems in most developed countries. And the answer is quite simply, we're totally open in Canada to, it's not binding, but receiving the jurisprudence from the other provinces, even from around the world. And so your law is gonna develop faster, and then in a couple of the trial decisions I'll show you, it's 65 pages long. There's a lot of thought and learning and how you process the evidence of each witness, which is very atypical from the typical US decision that I see. And so it's a lot easier to build on that knowledge and advanced knowledge when you get that sort of insight. So how are the court systems dealing with intransigent family dysfunction? Do they just give in? How directive are they prepared to be? What tools can they bring forward? Which is the third point. And frankly, there are few tools. The court has to be very directive and create accountability. Therapy is necessary in all of these cases, because not that the therapists have magic wands, they don't. And one of the things I'm gonna show you is a legal brief on failed therapy. Case after case after case where judges remark on the fact that conventional therapy of various sorts has been tried and failed with this family, so I have to do something structural as the judge. I can't, we're not gonna go back for round 4, round 5, round 6. So why do we still advocate for therapy as at least part of the answer when there's this remarkable track record of failure? You can count on the failure of therapeutic involvement in these families. And it's usually because it's unstructured, there's no accountability, it's a blank slate for the parents, the therapist has no power over the family system. So when I do a structured intervention involving therapy, I try and solve all of that in the referring court order. I'm giving the therapist power over the family system in various ways, not the least of which is the ability to write a report to the court, the ability to convene case management calls with hopefully there is a case management judge, and the therapist's ability to compel the parents to comply with the therapist's directives because I built that into the referring court order. So I don't do family therapy in these situations unless it's structured family therapy. Even then, it is easily sabotaged because the favored parent and the kids may just not be invested in success. They're invested actually in the failure. And it's very easy, if you think about it, and we have some clinicians here, to understand what's gonna happen in session. People are not gonna move off their narratives, they're gonna try and hijack the therapeutic forum to just be another battleground over who's right and who's wrong. So the number one tip that the successful family therapy practitioners use is you don't debate the past. You allow people, as a matter of fact, you teach them that people can experience an interaction in completely different ways, and that's not great, it's not optimal, but it just is. And so instead of debating that, can't we just focus, take a future focus, try and craft a family constitution for healthier relations going forward that preserves everybody's egos about the past. And so the operative language in the referring court order that I developed is that the family, including the children, have to be prepared to surrender past narratives, have to be prepared to follow therapist directions, and the therapist is responsible for maintaining a future focus, though informed by past difficulties. So we look at the areas of dispute and rancor, and we say, how could we do it better? So we're not looking at who's to blame, just this topic, the subject matter. This is gonna come up again in future. What should the rules of the game be? Both process-wise and substantively, so that the family is better equipped to get along together going forward. And the therapeutic interventions that I've seen and participated in that use these tools do a lot better. They can still fail, and they still do fail, but they still have a purpose, because everybody would have learned something, and the ultimate remedy of a reversal of primary residence, what I call a protective separation, is looming in the background. One of the few tools that the courts have, looming in the background. That's the therapist's ultimate power. Say, look, we don't want to have to do that, but if this process isn't successful, that's probably where the court's gonna go. So I'm asking you to work with me here. And what are we asking of the children in any event? Treat your mom or dad with the same love and respect as you do the favorite parent. That's it. And so you can imagine the conversation, because this is the conversation that we have with the children after we put in place a protective separation. you know, you don't have to be I know you're upset, this is not the outcome that you were hoping for, but let me explain how you're driving the bus here. Because you can get your mom/dad back in your life. You're in charge of that. If you can demonstrate love and respect for the other parent, like you do your mom, dad, the world's your oyster, and the court's gonna move the other parent back in. So we're not asking too much. When it's framed in that fashion, you see like those old Ford commercials where the light bulb goes on and the kids clue in and they said, oh, okay, you know, I can manage that. Whereas before it had never been framed that way for them. Before it's framed for them as a zero-sum game. If you're nice toward your dad, it means you get less time with me, your mom, and we don't want that. So, you know, I'm gonna maintain tight control. A protective separation or a therapist saying it's a possibility flips it on its head. If you'd like more time with your mom, be loving and respectful toward your dad. So I've completely flipped the incentive structure in the family system on its head, and that's why when we look at the data on protective separations, they work. Time and time again, family systems that have gone through 5 separate therapeutic interventions over 4 years, multiple trips to court, failure, are solved by protective separations. We would prefer not to have to go that far. But it's a necessary remedy. And it goes to this whole, we're gonna deal with lying and exaggeration and gaslighting. But how do you defend it against false allegations, the secret sauce, because they're rife in these cases. And then this whole political sort of controversy about PA is motivated by a world that doesn't want practical remedies, because the homeostasis and failure they think works to their benefit, and so they don't want the solution, and hence they throw all these pejoratives at the concept. So just as a quick aside, so that I don't actually have to deal with that, you'll see a slide fairly early on from one of my cases with the best definition of parental alienation I've ever seen. But it's too long, it occupies an entire PowerPoint slide, so it's not accessible. We need an acronym. We've all gotten into the habit of using parental alienation as an acronym, and we could all have different specific meanings for it, but we all generally know in a layman's sense what it is we're talking about. We're not necessarily saying it is a specific clinical diagnosis or definition. We don't have to, for reasons that I'm gonna show you. We just have to kind of think of it as, what is the primary, not exclusive, but what is the primary reason for the dysfunction in the family system that is never resolving, never self-ordering. This family will not, absent an intervention, restructure itself into 2 equal, healthy, happy homes. And why is that? Generally, it's because somebody doesn't want it to.
Right.
Because it's the natural order of affairs. Kids are built, I'm channeling Dr. Childress here, a couple of million years of genetic evolution, they're built to take in caregivers, not push caregivers away. It just, so an estranged parent says, oh, there we are, fabulous. You did it. Okay.
Do you know what slide number you're on?
Yeah, I'm way at the beginning. Topics for this presentation.
If you go to slideshow, it starts from here.
Number
and
3,
goes on.
yeah, probably, yeah, right there, perfect, okay.
And go to slideshow at the top,
Oh,
at the top.
oh.
There you go, that's fine.
Okay, perfect, okay, okay, thank you.
You're welcome.
Okay. All right, so, so by way of background then,
Great job.
that's how I generally approach these cases. The naysayers try and scare the court that what we're trying to do with these interventions is somehow harmful. And they have all kinds of tools and tips and tricks that they use. And you do this enough, you can almost predict it. And you have to have your repertoire of how you're gonna frame the case and how you're going to scare the judge into thinking that a non-decision or a decision to just try the same thing over and over again, which of course is a layman's definition of insanity, is not the right way to go. Because there is only one healthy result, and that is kids come out of childhood with two bonded parents, with relationships that are strong enough to survive the busy young adult years, and they'll have a parent over the life cycle. That should be the goal. You know, there's a famous line in the movie Apollo 13 where the flight director says failure is not an option. And far too often you get judges saying to a parent, I'm sorry ma'am, I'm sorry sir that we couldn't do anything for you, and then they make some sort of aspirational, not evidence-based statement. But I'm sure your kids are gonna reconnect with you in future, and Mark's experience is typical of most over the years you drift. It's the job of this system to make sure that there are bonded relationships built to last a lifetime the way they were intended coming out of childhood. There's a very robust body of social science literature, and I'll show you some of it, that it's beyond controversy. Very, very dire future for children who lose a parent in childhood this way. It's beyond debate. It's settled science. And so that's a certainty, and what we need to do is show the court that there's only one way to get there, and that is you have to cut through the noise and the smoke and the mirrors of false allegations, and you have to decide, and this is part of many jurisdictions' legislation, often called the friendly parent principle, which parent is best able to support the kid's relationship with the other parent.
Brian, I'm gonna be rude, but
Sure.
I'm a little bit concerned about time.
Yeah.
Because you said 53
Yeah.
slides.
Yeah,
so-
well, I'm gonna zip ahead. All right, so, okay. So, what is PA from a legal perspective? I think we've nailed it in Canada, where we consider PA simply an acronym based on a set of facts where the court decides what the primary causal factor is of the family dysfunction. That's not to say we don't look at models, and there are many models. So a lot of the people heavily involved in PSG subscribe to the 5-factor model, which is based on Dr. Baker and the late Dr. Darnell's revalidation of the original Dr. Gardner construct, where there's a certain number of factors in the child. When we see that pattern, as pattern recognition, we can get a sense of the driving force in the family system, particularly if it doesn't heal. So is there valid science there? Yes. Can you find experts to testify to that, as I recently did in a trial? Yes. Is it necessary? No. Why is it not necessary? Because it's not a clinical finding that requires an expert. Experts and prior jurisprudence can point to some of the criteria that are suggestive of what the problem is that has this family system stuck in a dysfunctional state. but none of them are definitive. All of them are just indicative, if you will. And the totality of the fact finding is relevant to that ultimate decision, which our courts have said is typical fact finding that judges do. So I don't have to, and I don't try to prove out any one of these particular models, even though I use them as a guide, and I will ultimately, after I prove out my facts in whatever the adjudication is, sometimes post them up against these models or ask my clients to organize their evidence against these models and other things that I'm going to show you. It's all helpful, but it's not necessary. So I don't roll the dice that, oh, look at that, I can only show 5 of the 8 factors, or am I going to get into a debate now that I haven't even satisfied my own science? I just don't go there because it's not necessary. And therefore, in Canada, and it's in large part because of some of the cases that I was successful in defending at a court of appeal level, not only do I not need an expert to tell the court what PA is, in one case the judge went so far as to say that it is so accepted now, he will just take judicial notice of the concept and that it's very harmful, and didn't even want to hear from my expert. I know what it is, Mr. Leiber. Move on. Wow, when we get to a world where they take judicial notice of it, all those naysayers in the background there, they're just noise. They just go away. Further, I don't need an expert to suggest that a protective separation is justified or required, because our case law recognizes what they call the stark dilemma. You get to toward the end of a case and you've tried all kinds of interventions, judicial admonitions, case conferences, compliance motions, all kinds of therapeutic interventions, parenting coordination, you name it, hasn't worked. What's left? And so our courts of appeal said it, you have 4 choices. You can keep going on and hoping that it works, doesn't make a lot of sense. You can impose equal parenting and say the kids will have much more exposure to the targeted parent and they'll figure it out, we'll keep going with some therapy. Sometimes you're ready at 50-50 and it's completely unhealthy, or there has been an equal parenting order for 4 years that isn't being followed. Why would you expect that the trial decision is suddenly going to be followed? It's the same fool's game. So what does that leave? What are the other 2 choices? One, you give up and you just say, kids are stuck in the middle, we need to release them, give them some space. Maybe they'll come back, maybe they won't, but continuing to try, you'll see the occasional decision, is itself traumatizing the kids and they just need peace at this point. Well, the science doesn't support that. It's frankly, it's a bit of a cop-out, a way to avoid making the tough decision, which is option 4. So option 4, a protective separation, it's a temporary remedy. It is inherently an interim remedy. It is meant, little diversion, but it is not meant to substitute one loss for the other. Why would we do it? So it is meant for the family to come back together and to wind up with 2 equal, healthy, happy homes, and it is often the only choice. So while you are gonna still, even in Canada, you're gonna try just about everything else first, we don't hesitate to do that if there's no other practical answer. And the more cases we have doing that, the easier it is to get that remedy. And I'll show you a statement of law that makes that. So
Does
here,
the time separation create further alienation that's almost unrepairable? Had this taken place early in the process, before all the mishegas
Right.
takes place, it's almost opposite what really should take place.
Right, and we do have judges saying that these sorts of interventions should come early in the case at the earliest possible moment, because we know from the therapeutic world that the longer it goes on and the more individual attempts at therapy that fail, the harder it is to solve it. So why does it take a trial? And some of the trials I've done, there 4 weeks of evidence, 5 weeks of evidence. Who can afford that? How do you get a judge available? You know, like that means the trial's gonna be spread out over 3 or 4 months. Right, you know, in Florida, it may not even be practical. They're hard to prove these cases, but with models and knowing, you know, it's the 80-20 rule, what do you really need to prove your case? It can obviously be done in a lot shorter period of time. But of course, that's a great point, is that you want to be going to the ultimate remedy, if it's necessary, early on, before things get baked in. This definition up on the screen is what I was referring to before. So there's a 2011 Manitoba case. This is a sign of what Canada is doing so well. So it is just a perfect bulletproof description of what PA is, and the denier community can't touch it. And it would have been lost in the din of time, except for the fact that I loved it, and I kept putting it in front of other judges. Look at this, look at this, look at this. And so Dr. Michael Stambrook never testified in any of my cases. But the way things are in Canada, an Ontario judge can say, I like what that psychologist said in that case from a decade ago, and I'm adopting it, even though that psychologist obviously never showed up and testified in front of that judge. So we can even rely on expert evidence from other cases in other provinces, and the judge can adopt it as a very good contribution to the analysis that they have to do. And ever since I got Justice Van Mel, who was a very senior judge in Ontario, to adopt this, it has taken on life, like lit kindling on a forest floor. And there's multiple cases now that are saying, Justice Van Mel recognized this as a really good definition, and off it's gone. So it's been given new life. And by the way, most of our cases are accessible just to the public. Okay, so I think what I'm gonna do is, okay, so I've given you a taste, the 5-minute tour, so to speak, of how I argue these cases when I need either a second to last stage, a highly structured intervention with 3-4 pages of parental covenants, some of which are there to support the therapeutic process and empower the therapist, as I described, some which are there to just conform the parental behavior in support of healthy relations generally. So either at that stage or the next stage where I have to get a protective separation, as I did in both Boers and Wilson and Sinclair. As a matter of fact, January 3rd, we have the final day of the review proceeding in Wilson versus Sinclair. And the nice thing about how, like the multiplier effect of all of this jurisprudence, is that on the back end of every protective separation case is a review proceeding. Why? Because often the judge is still seized, wants to know, even if the parents agree, yeah, it's time to reintroduce the other parent, judge is responsible for making sure that it's done properly and structured, etc., and that the kids have healed. So you get a review decision that recognizes that the protective separation worked. And for each protective separation case, there should be a corresponding review proceeding which recognizes that, and then over time Now, when you go and you ask a court for a protective separation, you can state with confidence, here's the science that they work, because some of the more formalized programs have been studied, and I'll refer to that shortly, and here's the jurisprudence saying that it works. And if you have any doubts about what you're doing because you haven't done it yet yourself, Your Honor, let me explain why they work. And then the judge gets the speech that I gave you here today about changing the incentive structure in the family system and explaining to the kids that they're actually in charge and all they have to do is conform their behavior, which they can easily do, etc. And it all comes together. And this kind of behind the scenes, the secret sauce is Harman, Kruk, and Hines and more recent articles all about the fact that PA dynamics are both domestic violence, which has been ratcheted up in a lot of the legislation as the number one factor, or they call it often family violence, and number two, child abuse. So if you wouldn't hesitate to remove a child from a parent who doesn't feed, clothe, house them, get them to school, why are we so squeamish about removing a child subject to what is clearly emotional abuse, which is one of the listed factors in our child protection legislation that ranks equally with physical harm. So it's an education of the court as much as it is as well an education of the various participants in trying to help the family. So these are some of the tools and some of the more recent articles, and I have all of these, so if anybody's interested, just email me afterward. So Mandy Matheson, who's an active member of PSG out of Australia, and her group have done a lot of research on the impact on children. Jen Harmon, who many of us know, out of Colorado, who's a prof at Colorado State University, has published extensively on the damage. Jen was an expert who testified in Wilson versus Sinclair, and you'll see what the court did with that. And then you have all the jurisprudence itself that talks about PA dynamics as being child abuse. So it's all there. It's just a matter of organizing it and presenting it in a compellable fashion. Okay, now what isn't PA? So what can look like PA but is not PA? So we have these other concepts of gatekeeping and enmeshment. Gatekeeping, many of you have heard of. It doesn't mean that you're trying to provoke unnecessary anxiety or hatred in the child. You're just, for however it happened, you're in control and you're doling out parenting time to the other parent with an eyedropper. And that's inherently harmful, but it is also an example of family violence, coercive control through the children, or a term that I invented in a case years ago, days for dollars. You tell me how many days in a typical 2-week cycle you'd like with the children, and I'll tell you how much it's gonna cost you in the financial part of this case, and we'll all be happy, because I control the children, and I'm certainly gonna use them as leverage in the other part of the case. And you know, it sounds wild, but it is a very common occurrence. We have case law that a parent exhibiting gatekeeping behavior is not prioritizing the needs of the children. So use it. You don't have to prove that it's a PA case. You can just say who's acting as a friendly parent, who's gatekeeping. Children benefit from maximum contact with both parents. You kind of know who the offender is. If the Child Protection Authority saying not seeing any child abuse in this family, so they're looking at it as simply a custody and access or parenting time dispute, what right does one parent have to dictate the parenting schedule of the other parent? You know, they're inherently biased. So enmeshment. Also, it's not PA, but it can produce, like gatekeeping, a result that looks like PA. So you have to know what you're treating. The medical analogy is diagnosis before therapy or treatment. So, enmeshment. Think back to Dr. Warshak and his articles about PA being counterintuitive. On the one hand, parent and children all lovey-dovey, and it's beautiful, everything is smooth, everybody's happy, no controversies, they don't have a single negative thing to say about that parent. Well, those of us experienced with the pattern recognition, that's not natural. All kids have issues with their parents because they're not in the power position, right? So when a child said, no, my mom is perfect, no, it right away, you just, okay, there's one criteria. But there is a concept in parenting, and particularly in the concept of intrusive parenting, where you're too close. So it's not a continuum of wonderful and problematic. It's more of a continuum of too close and enmeshed on one end, and detached and unempathetic and perhaps harsh parenting on the other end. It's like Goldilocks and the Three Bears. And the sweet spot is in the middle, where the children are allowed to individuate, and the parent understands that I'm their parent, I'm not their friend. And in a lot of these conflictual families, you have a parent who, usually these dynamics predate the separation, the kids are their friends. Right. And they use that as power in the separated family dynamic. So, those of you writing can write this down. If not, just ask me. The best article on enmeshment was written by a clinician, Patricia Kerrig, K-E-R-I-G, and I'm happy to email it to people. What is it? They say that the number one law that is breached everywhere all the time is copyright law. So, but imitation is the sincerest form of flattery, and I'm sure this is fair use. So, Patricia Kerrig, there was an edition in a peer-reviewed journal, all focused on boundary violations. And you have boundary violations in all sorts of relationships, parent-child, very, very common. And she was the editor of that journal edition, and then Howard Press published it as a book with the phrase boundary violations, I forget, it's a long phrase in the title. And her article on enmeshment is fantastic. And on one page, she has a list of all the different labels of family dynamics that are aspects of enmeshment. So you have parentification, right, where the children are elevated to take care of the parent, a very common dynamic. You have infantilization, where that parent will never let go. Quite often it's the mom, because after I gave birth to them, they're part of me, and I'm just not comfortable not being part of their life half the time. It's very, very common. But that list has about 40 different labels, and it's actually quite interesting to go down and see how many different ways enmeshment can manifest itself. So you actually have the reference here to the textbook and the journal at the bottom of the slide. So important to come up with the remedy that is necessary in the particular family, and to distinguish alienation cases from simple, not that it's simple, but gatekeeping and enmeshment are not necessarily PA. Now when you see the anger, hatred, hitting variant of a PA case, kids that are kind of inflamed to that level, I wrote an article about a year and a half ago for the PSG newsletter. It was an homage to the then recently deceased Justice Gomery from Montreal, who had, and those are really, really, really interesting article, I think. So he did one of Canada's first PA cases, 1991. So Dr. Gardner's work was only published in the mid-80s and kind of refined over the late 80s. So here you have a case, 1991 in Montreal, where when you look at it 30 years later, because I was writing in 2021, it's still state of the art in terms of and it's a short decision, and he just nails some of the most problematic areas we're still struggling with such clarity. It was absolutely a tour de force, and it's mandatory reading. Interestingly, for those who've been doing this as long as perhaps Mark and I have been doing this, the mother in that case, the targeted parent, who was awarded 2 of the 4 children because the other 2 were kind of older and it was just felt they couldn't be saved, was Pamela Stewart Mills, who went on to found the Rachel House in Texas, the first formal reunification therapy program where a lot of today's practitioners cut their teeth. And it just a fascinating piece of PA history. But those of you who haven't seen this, the concept of PA history, and there's some good articles out about it, including in the Family Court Review, where they've done targeted issues in 2000, 2010, and 2020, where the entire issue was devoted to PA. The term parental alienation goes back 200 years. There's early 1800 US and UK jurisprudence and newspaper articles that use the term PA. So Dr. Gardner, this is not owned by Dr. Gardner. He was just observing intractable cases in his own practice, trying to conceptualize it and learn from them. He was seeing patterns, and he couldn't solve those families. They were like a brick. No matter what he did, he couldn't solve. They didn't want to be solved. And so he went about studying them. What are the common factors? I'm a very skilled clinician. I've been doing it 30 years. I can't solve these families. What is it about them? And from that, he developed his syndrome concept, which is really just an acronym for a pattern. But we're just describing human behavior. And it goes back as long as there's been marriages and kids, this has been around. And for those other students of history here, Einstein himself, in and around 1910, bitterly complained that his wife was alienating his kids from him. So there's a long, long history of this maladaptive practice after a difficult separation, because feelings overwhelm the cognitive part of the brain of people. So I've referenced here the Family Court Review, and in particular Dr. Lorando's article, another colleague and friend of mine, who's both a clinician and a lawyer, just recently stepping back and retiring, but still involved in a lot of the research and advocacy work. You can access a lot of our law for free on canle.org. The LI stands for Legal Institute. And you can access European research on bailey.org, and all of this is free. And I've found that when I do my US research, case text is way more cost effective than Westlaw or anything equivalent. Okay, so Judge, the problem in legal remedies is the judge is sitting there, hasn't met anybody, gets 2 conflicting narratives. It's a swirling mess of allegations, and the alienating parent is doing the proverbial throwing mud and spaghetti at the wall, hoping that just enough sticks to confuse the court. And another phrase I came up with, for an alienating parent, a tie is as good as a win. So when you get these decisions, pox on both of your houses, you're both failing your kids, and the alienating parent is inwardly laughing. They don't care. Yell at me, scream, I don't care. I'll be out of your courtroom in 45 minutes, none the worse for wear, and I still have my kids. A tie is as good as a win for an alienated parent. That's the steep hill those of us on this side have. And part of the mess is, I'm assuming everybody's familiar with the whack-a-mole game, that somehow the digital version of a whack-a-mole game is never gonna substitute for the real arcade game. But it's no sooner do you deal with one false narrative than there's another 2 or 3 taking their place. I guess in Greek mythology, the Hydra sort of scenario. You can never get ahead, you're always falling behind. And that is the experience. But that's not natural. So, good analogy, there's a family therapy mandate that is just nearing an end now. One parent has been fighting to get out of the 50-50 for as long as the child has been around, and the other parent is quite weary and frustrated. There was a complete cutoff of parenting time a year and a half ago. Took a year working with it to get it back to equal parent. And so you say, was any of that necessary? And you look at the narratives that came out of the child's meetings, which happened far too late in the process. And there was no substance, it was ephemeral. So you would think the child would lead with the most important grievances. There was nothing there. The 3 most important grievances were all discussed and resolved in the first session in which they were raised. Okay? Because the minute you actually, Justice Brandeis, US Supreme Court, 20s, sunlight is the best disinfectant. So the minute you put the spotlight on it, say, okay, so you're saying this, let's explore it. And then like a dream, which dissipates, you can't even grab the dream. It's just as you're coming awake, it's all dissipating. Each narrative is gone. So we report back to the case management judge, I don't know, the father for 10 months, no one has told him what the issue, the mother couldn't even tell him what the issue was or didn't want to because it served her purposes. We finally, 4 months into the process with the therapist, again, very bad clinical practice, have the first meeting, therapist, child, and father all together. It had been siloed up until that point, another major area in clinical practice, siloing. You can never solve an individual issue in siloed sessions, which is why individual therapy is fatal. Parallel individual therapy is generally fatal to family therapy. The two cannot coexist except for the individual therapy being subservient to and reporting to the family therapy. But that is a whole in-depth topic for another day. So in this game of whack-a-mole, the 3 biggest ones are all gone in one session. So the child has to invent more because the child's trying to cover up for, why am I not going? I'm going to be exposed. And you go through round and round of this till finally the therapist I think this kid is lying to me. Really? Really? Is that a revelation? You've never had a child lie to you before? Common misconception. Pox on both parents' houses. The child's the only one who's telling the truth. Both parents are lying to me, the therapist. No. You experienced clinicians start off with the view that the child caught in the middle doesn't really have freedom of action. And it is only after a forensic process that you get to the truth. And the truth might be 2 ships passing at night, they just didn't hear each other, or the truth could be an out-and-out lie, an exaggeration, tiny little kernel of truth, embellished and developed because it's never been challenged, it grows like a cancer. But whatever it is, you're not going to sit there and judge somebody's body language and facial expression and come to a conclusion about who's telling the truth or not. Even, there's studies even of trained police officers are wrong as often as they're right when they play that game. Oh, I can spot the lie. There's only one way in the scientific literature to determine mistake versus lie versus embellishment, and that is you go out and you test through collateral evidence and through changing the dynamic a little bit and seeing what happens. In other words, play with the inputs and see what the output is, and then you get a sense of what the reality is. And if people are anchoring on their narrative, say, but your mom did this here, how could that have happened? And your mom raised you successfully for 12 years. Why is she now, you never want to see her again because of one perceived slight? But they anchor on it because if they show any movement at all, they know their story falls apart, and then they're gonna have to see the parent, right? Go ahead, Ron.
What I experienced in this situation as the alienated parent was that my kids saw the anger directed to me, and if they didn't support our narrative, the anger was directed to them.
Right.
My ex-wife stopped talking to one of my children who had colitis, and so the bottom line is the anger that was directed to me when they didn't support her became directed to them.
And passive-aggressive practices are very common amongst alienating and gatekeeping parents. But the people on the outside don't get to see it because they are often the old cluster B types. They present very, very well. I was just in court 2 weeks ago with an alienating / gatekeeping parent, so sweet, and the judge even remarked that, oh, so-and-so is supportive of the child's relationship with the other parent and everything. The next day, the blistering emails, accusatory, anger, hate-filled, we're back to flowing again. They just, I can come into court and I can smile sweetly and I can con the judge for the limited 1 hour case conference. And it just, surfaces can be so deceptive in this area. That's why you need lots of collateral evidence. Okay, so continuing on, how do we, the ultimate question, how you cut through false allegations and pejoratives? The targeted parent should never be held to a standard higher than that of a parent in an intact family. So I came up with the rhetoric of the intact family standard. Parents in intact families aren't perfect. They occasionally come home from work, they had a bad day, their boss screamed at them, their project didn't get accepted, and they don't exhibit the patience and resilience. They walk in, the house is a mess, no one's done this or that, and they lose it. It happens. It's not good, but it happens. Does that family splinter? No one's talking to each other anymore? Or does the next morning hug, kiss, make up, forgive, forget, move forward, because we're a family? So why should a slip up, because all targeted parents are going to make a slip up, all favored parents are not perfect, suddenly justify, the label, you're a hothead, you're a bad parent, you're an abusive parent. So you just have to be normal. And what normal means, it's a very, very broad range of parenting styles that will still raise a healthy, well-adjusted child. Very, very broad range. We want to see some of the stuff listed on this slide. Take an interest in parenting, do some courses, read some books, have a good attitude toward parenting. Want to be the best parent you can be. Don't just wing it because mom did it this way and dad did it this way and my friends' parents did it this way. There is science out there. When I started this journey, and I was also an intuitive parent, there's got to be some science out there, so where do you start? How about universities that have family studies programs? Good place to start. How about somebody on the faculty of some US university has Smith on Parenting, 15th edition? oh, that would seem to be a good place to start. And so you start your journey there, and then you get into more specialized topics and some of the topics, emotional regulation, etc. So for those of you who are interested, I have it's probably up to something like 320 volume, personally curated parenting library on the types of topics and skill sets and problems that we see in these conflictual families, which I'm happy to share if anybody wants to see that, because if you go to Amazon and you type in parenting, you get 116,000 hits. It's not accessible, right? So I've done that work for you. Just when I get a book review or something like that, and then I look into what that author has published, and it leads you on other trails. So I've done that work, and I give my clients my parenting bibliography, saying, you pick some books on those topics, and I'll pay for it. I'll go on Amazon and send you a shipment of those particular books that you're interested in, because then you're going to be a better client. So they all my clients get these homework or / gifts on my files. Now, what's the but-for test? The but-for test is another Ludmer invention in the how do we deal with the swirling narratives. If the parent-child relations would still be intact, but for the actions of the alienating parent, you got yourself an alienation case. Everything else would have been solvable in 1 or 2 sessions with a skilled therapist, parent-child having difficulty negotiating chores, bedtimes, gaming, whatever. The parent needs some help with their language, with their negotiation skills. Child needs a little bit of guidance as to what's normal with other parents. It can be solved, even if the targeted parent made mistakes. But you could solve that, and here's one of the tests. Targeted parents are motivated. In therapy, they're like a sponge. Help me, tell me what to do. I'm there, I'll do it, I'll read, I'll take courses, I'll apologize, I'll do this, I'll do that. They're desperate. But like the game of whack-a-mole, no matter what they do, it doesn't heal, it doesn't solve. You solve 2 narratives, there's another 23 behind those. So the but-for test is very helpful in trying to discern what's really going on. So, false allegations, right? Children's behavior is extreme. It is disproportionate. There's another criteria that we've all seen in these cases. Okay, I understand, you're mad at your mom, right? But never gonna speak to her again because she embarrassed you in front of your friends. Seems a little disproportionate. I think you're gonna have trouble in relations in future unless you learn how to manage this sort of thing. So that's an obvious tool. But you've been accused of X, you've been accused of sexual abuse, you've been accused of discernible acts. How do you, firstly, do you have to? Is it fair? Is anybody requiring you to prove the negative? Or else we assume you're guilty, so to speak? Why do we assume you're guilty? Well, the child said so, and we believe the child. And if you, I've already mentioned that, it is unbelievable how many verifications from child protection authorities are made solely on the basis that, and this is a live case that's going on as we speak, including yesterday when I didn't even get to leave my hotel room. We believe the most vulnerable member of the family system. So you co-opt the child to make a false allegation, to trigger a child protection investigation, and you're guilty before it starts because they're gonna believe the child. Then when it gets reported to the court, it just a conclusionary statement. The society, which is what we call our authorities, the society has verified physical harm by mom, the society has verified risk of emotional harm from dad, okay? And then you kind of dig to the bottom, I don't understand. There's this, all these slides that you'll see in a sec. I've proven a negative. How can you make that verification? Did you read all the stuff we sent in? Did you read mom's motion materials? Did you read our reply affidavit, ripping apart dad's materials, showing the lies? No. Well, in your letter to the court, it doesn't quite say that, does it? Not very helpful. I've had clients charged with sexual abuse. Charge first, you'll work it out with the Crown Counsel later, and takes a year and a half to get the charges dropped, but meanwhile the whole family law case is all messed up because people aren't thinking forensically. So if you take a typical, how many here are familiar with Bayesian reasoning? Anybody? Bayesian reasoning. Okay, so Bayes, B-A-Y-E-S, theorem. It's if you learn logical reasoning, it's one of the tools, and it all starts with understanding base rates for certain things in the population as a whole, and that leads to your understanding of the likely clinical hypotheses. So what is the rate of sexual abuse of children in the population as a whole? A subset of those, the person is so sick as to perpetrate this against their own child. Tiny, tiny, tiny sliver of the population. How many of those just happen organically and there's no divorce or separation going on, versus how many where there's no prior history, no prior indicia of maladaptive practices, but suddenly, for the first time ever, in the midst of a case, you get this most horrific of allegations. So you're talking 0.0001% with no prior history, and suddenly in the midst of a case where they know, so this is 0.16, which comes actually later. The concept of hypervigilance is a great tool. So early on in your family law case, you get accused of X, and it doesn't have legs and it doesn't stick. But you say, oh, okay, this is what I'm up against. I'm going to be triply careful. I'm never going to be alone with my own kids. There's always going to be a relative over visiting. I'm going to put cameras in my house, and on and on and on, because I know I kind of have a circling shark out there waiting for the slightest hint of blood in the water to, okay? And then 2 years later, there's another allegation. So the first thing I do is say, not very logical, because the base rate for this is, in these circumstances, 0.001, and the parent was hypervigilant because they had already survived one false allegation. And can you make a false allegation and you're throwing all the pejoratives you can into the case, but you happen to forget, it's like Columbo, like, you see, I use all these analogies from the movies and TV, and I'm increasingly speaking to younger audiences, and sometimes it's like crickets, like kind of thing. You know, when I was speaking to like 400 people, and I said, it's kind of like Bonfire of the Vanities. And I was like,
No, but
nothing. It's like Rodney Dangerfield. Is this on? Is this on? Okay. Do you know what I mean? Bonfire of the Vanities? See what I mean?
Do you know
Okay.
Columbo,
There we are.
right?
Okay.
I don't know Columbo either.
Oh my
You
God.
gotta Google
Okay.
it.
Oh.
Walk.
Walk, my favorite.
Okay. So this is unfortunately what
The
happens.
Bonfire of Vanity is a terrible one, but if you don't want to
Book
read
was
the book,
fantastic.
the book was good, but yeah.
Yes,
Oh,
yes.
that was great.
So
Movie
They
form.
do on
look,
one of the
but
old stations, they have Columbo.
thankfully, the generation coming up of upcoming practitioners has Google and
Yes.
YouTube, so you'll be able to get up to speed, and then my analogies will
Will
make
make
sense.
sense.
Okay,
What
so
would they do without it?
so another tool in dealing with false allegations is nobody holds back the good stuff. It's just not the way we're motivated, and if we're gonna try and kill the other side of the case, we don't hold our best material back. So if there has been this prior allegation, and it's that there are 3 kids, and our youngest, had the skin condition, but you were kind of going way too far, getting, passing boundaries, kind of thing, you were molesting our youngest daughter. And 2 years later, the story is all 3 daughters. I'm sorry, I don't even have to start looking. Not credible. Because you don't hold back. You don't suddenly discover, oh, I forgot, like Columbo, that's where Columbo comes in, like, there's always the question coming out of the blue at the end. One more thing, sir, okay? You'll see the on the videos. And
She's gonna run home tonight.
you're right.
She's definitely not.
I will Google it.
You'll Google it. And so people don't hold back when they're gonna let you have it with false allegations. They throw everything at you. So if the story morphs, it gets, okay? It's just, it didn't work, it didn't stick the first time around. They gotta come back with something better and deeper and scarier, but it doesn't happen. That's not the way life works. So over time of fighting off false allegations cases, I have developed the 16 tools. Okay, Gardner had his 8 manifestations of the child. I've got 16 tools, and time is not gonna allow me to go through them all, but they're here on the slides. How do you prove a negative? And 15 tools. The 16th, which comes up a little later, is hypervigilance. So I'll leave those to you. Hopefully some of these will resonate with you in your practice, but base rate and hypervigilance, part of tool 14, okay? All right, now, demonstrative evidence. So if the mirroring had kept working, if I didn't try and get too fancy and try and record this, I would have shown you examples of demonstrative evidence. The simplest type of demonstrative evidence is charts, simple tables that you build in Word. Come to court after 4 years, the Wilson versus Sinclair trial had 7,200 pages of Our Family Wizard messages. No judge is gonna read that. So we put the brief in, and each side did, subsidiary briefs of what they felt was demonstrative assertions that they actually wanted to show the judge what's been going on, but if anybody wanted to cross-examine or see the full chain, it was there in the full thing. So think about your sources of data after 3 or 4 years. You have depositions out of court, and in honor of your US types, I use the US word, in Canada it's called questioning. You will have assertions in affidavits along the way in various motions, case conference briefs, things of that sort. You'll have inter-party correspondence, you'll have inter-council correspondence, you'll have Child Protection Authority records, police records, whatever, and then in Wilson versus Sinclair, there was over 40,000 pages of documentary evidence, not accessible, and no judge is gonna sit down and read that and try and figure it out themselves. That's your job as the counsel and clinician writing a report. So we use demonstrative evidence, and what do I mean by that? In Wilson versus Sinclair, the children's dysfunctional behavior went through stages. First, they wouldn't come at all. Then they would come, but they would only park on the front lawn on a blanket. They wouldn't go in the house. Then they would go in the house because it was winter, but they wouldn't leave the vestibule. Then they would leave the vestibule, but they would only go in the music room. They would never use the washroom. They wouldn't eat their food. They expected him to bring the food into the music room, which he couldn't do, and it was dysfunctional. He simply wanted them to sit at the table and share. And they would or would not allow him at their activities, and on and on and on. So it went through these stages as the pressure mounted, and it was starting to look ridiculous that they wouldn't even enter the home. So they'd enter the home, but not really enter the home. Things of that sort. So we charted it all. The different stages of the children's dysfunctional behavior. And they would only wear masks going to see their father, not anywhere else. You would see them coming out of the car, putting the mask on, like they're heading into the danger zone, which is all part of the symbolism. It wasn't lost on the judge, by the way. And we would then, so that would be, say, our horizontal rows on this chart. And then the vertical rows would be source affidavits, and the cells would be, you know, what page, what paragraph number of that particular affidavit, is there a reference to this dynamic?
Mhm.
And we would do the same thing with the other sources of data. So now I boiled down 40,000 pages of documentary evidence to 50 events, assertions, behaviors, and where you'll see it referred to. In another case, I built a chart of the actual false allegations. Dad is this, dad beats the children, dad does this or doesn't do that. And I charted it through all there'd been like a prior case and a final order, family still didn't settle down. So it was years and years and years. And I showed the evolution of these allegations over time. And from that, one, you know, you format it, you have to print it out on 11 by 17, right? And most office type printers will do 11 by 17. And that one sheet alone told everybody exactly what it was going on. Mother anchoring on this allegation, then it's gone. And it disappears and it's not referred to anywhere else. She doesn't raise it with clinicians, whatever, and then 5 years later, it's back. Or something, it doesn't exist, and then consequent upon a motion didn't go her way, something appears. But it's not something that happened then, it was a Columbo moment. You know, and it was like 4 years ago, not credible. And so this one chart showed the judge, you know, some really good cross-examination and confluence of evidence, but it made all of that, in that case it wasn't so, well, somewhat heavy on the document, but much more on the narrative evidence. You could bring it all together in a chart, and a picture truly does tell 1,000 words. So that's what I mean, or the allegation morphs. So in Boers versus Boers, which is the case study I'm gonna show you in a sec, there was an allegation, the father pushed his daughter down the stairs. You know, kind of ridiculous, right? Right away it tells you, you know, not very likely. Well, the reality was, the son had been sleeping upstairs and he held her back from going upstairs. And she stumbled, like she had only started to go up the stairs. No, you're gonna wake him up. And he kind of held her back and she stumbled a little bit. That was the reality. But how it appeared in the mother's discourse was, and you saw it morph over time, he knocked her down the stairs, he pushed her down the stairs, he threw her down the stairs. So it actually, they were all wrong, but it evolved over time to being more and more and more calculated and deliberate. So when you can show that graphically, instead of in narrative cross-examination, okay, can you turn to this, and in this affidavit you described it this way, right? This, I charted it, and I showed the picture. So through these charts, just Word documents where you think about your rows and your columns and your cells, an amazing tool in a complex case. Okay, so I'll skip past this. There's a lot of jurisprudence on false
Do you
allegations.
think that ever can be used to go back with the kids years later, as they have some issues coming up about what really took place during that period of time?
Oh yeah, so kids are gonna be very curious when they're young adults as to their journey. And they will want to see, and they will want to read. And if they're approaching 24, they can probably handle it. And they're entitled to kind of know what happened, their own self-discovery. Like, why, everybody else has a dad, like, why aren't I close with my dad? And they'll want to explore that, and they should be allowed to explore that. Reconnecting with alienated young adults is a sub-specialty. That game has to be played very subtly. And probably the worldwide expert there is a good buddy of mine, Dr. Josh Coleman, out of Oakland, San Francisco. He's got a website, does webinars, prolific author. So just if you look him up, that would be the go-to person for adult estrangement. He's published several books on it as well. But it's a totally different expertise and dynamic than
Coleman or Goldman?
Coleman, C-O-L-E-M-A-N,
Josh?
Joshua Coleman.
You've used gatekeeper and enmeshment, and it's just occurring to me now, has there been any sort of, this is psychological Munchausen by proxy?
You do see that. Of course, that is actually a clinical diagnosis because it is recognized in the literature. And it's obviously harmful to kids, right? It's gonna make them petrified about everything. Pathologize your own child, like how crazy for your own benefit. But that one you would need, and most of us know from a layman's perspective what that looks like. But that one you really would need a clinician to diagnose, as opposed to just a parent who's a fraidy cat seeing specters everywhere because they lost somebody in the family or something like that. So I would I in my practice, I don't pathologize. Now the other side obviously thinks I'm pathologizing all the time, but I avoid the labels. So even if I think and convince they're a narcissist or they're borderline, or I don't go there. I beg my forensic evaluators, I don't want psych profile testing. Don't go there.
My next question, how much do you do with it?
No, I stay away from it. It is a lot, in my experience, a lot of wasted time and energy. Parents are faking good on those tests all the time. So you get a result back and it appears they're faking good. Okay, so what's the judge supposed to do that? Or, they have narcissistic and borderline tendencies. Okay, what's the judge supposed to do that? If narcissists are 10% of the population, Bayesian reasoning, narcissists and borderlines, etc., then they're probably 15 to 20% of high conflict parents. And they're possibly 20 to 25% of alienating parents,
Borderline?
or all cluster B together. But still, what are you supposed to do with them? We don't take children away from people because they're a borderline. We take children away from people, or we put them in the penalty box and let them earn it back by their behaviors. So how I deal with this is twofold. One, I want to actually make them look more mentally normal than they are. I use choices. This is a parent making very bad choices. Now they may be built that way to make these bad choices, but it's like, I'm sorry, then you just have to work harder than I do to behave normally because you have those tendencies. They're neither an excuse nor a sufficient reason to do something. It just is. The children need your behavior to be normal. That's a choice you make every day. Even if you've alienated. Sun comes up on a beautiful South Florida morning. Today's the day that I'm gonna stop alienating. Today's the day I'm finally gonna listen to that clinician. Maybe my practices are a bit enmeshed. Today's the day I'm gonna read a book on enmeshment to see maybe they're right, maybe I'm wrong. So I tar them that way. You were withholding the children 1 month, 2 months. So you get up on the morning of day 61. What did you do differently, sir, than the previous 60 days to get the children to their mother? And usually they got an empty bag. They're just, well, you know, it's not my fault. No, you don't understand. What did you do differently on day 61? And they're like a deer in the headlights because they're not doing anything differently.
Can I interject?
Sure,
on-
please.
So, in 2 cases that I've had recently with the pandemic and drug addiction and things like that, and parents have reappeared, and the other parent has now formed a life and doesn't really want to have that parent come back, and there's been a good year, both cases, year of sobriety. On day 61, there was no real big reason they were sober. There was things in place. I made the 3 people get into the room together, mom, dad, and child, and the alienating parent say to the targeted parent, I want you to have a relationship with your parent, with your dad or your mom, and everything, and all the reasons why, and all of this. And it was kind of like everything melted, and both families are still reunited. Now, there's been no relapses, there's been no anything, so it can actually, on cases that are not so firmly entrenched, but before the story gets really firmly entrenched, you really can do it, and the words are really like, not to say like, you're gonna be safe with your parent, you know, you're gonna be safe with your dad. Why wouldn't I be safe with my dad? Like, it's the words that are really powerful that the parents actually say, but you can, if you can get them into the room together, and you get that parent to say something like, I had a kid in there turn to the parent, go, but you told me they weren't safe, and you told me, and then the parent like was looking like a deer caught in headlights. The kid started hitting himself in the head, and the father was like, it's okay, you know, and the mom would just be like, here it is, you know, dad was, we knew that the other parent was saying all sorts of negative stuff, so there was guardians, there was people in place, and it was done very, it's worked twice. It hasn't always worked, but it has worked recently through the pandemic. So if you're doing something different, that's something to do different with your clinicians. I don't know
Right.
whether or not your clinicians will do
Well,
it.
but the key
I did
is,
it.
they weren't siloed. The siloing is fatal all the
I
time.
don't never
You-
do silo, you
Right,
can't.
you can't solve a relational problem in individual therapy. I was just, as a matter of fact, I had a proceeding with a judge this morning from my hotel room, where it's one of the sticking points in the separation agreement, because for some reason, parties are gonna agree on equal parenting, and the mother is pushing for the, you know, ability to have therapy for kids who, no one's saying they need therapy, they're young kid, what is this issue? And it's so obvious she's setting it up to line up a kid to come and dish about that to an individual therapist, so I just drew a line in the sand and said, we're happy to have a mechanism if a pediatrician recommends that the kids are experiencing bullying at school, whatever, and they need therapy, that's fine, but the minute that clinician identifies a relational issue, it's out of that forum and into a relational therapy forum because so much damage gets done. An article that is still current today, just like the Kerrig article, 2003 Family Court Review, Lynn Greenberg out of Los Angeles, who is a mentor to many, very big in AFCC, wrote an article titled, Is the Child's Therapist Part of the Problem? And it's a brilliant article, and as far as I'm concerned, it's mandatory reading, and it's all about the perils of individual therapy and how you manage that. And it's still current, so this is about the cumulative learning. So I only have a minute or
And
two.
I'll add
Yeah.
on, I won't take on a case for parental alienation or reunification or anything along those lines if you can't get both parents to be participatory.
Right.
They
We
don't
see
necess-
that all the time, you know,
Yeah.
I can't get kids to be evaluated about anything
Yeah, I won't
unless
take
both
on, it's like
parents.
doing a three-legged chair.
Yeah.
You have to have everybody involved or you're not gonna get any type, Mark, please don't, me, I don't need to be videotaped.
But
You-
what happens, you know, you've got, one parent who is constantly bad-mouthing the other. The kids need some counseling, and of course, that parent isn't going to allow it, isn't going to agree to counseling, and you can't get the child seen, and you know what the court system is, so I have this exact case, and it's months, and we're still trying to get in front of a judge to say, she won't agree to counseling these kids need it. The kids have asked if they can go see the counselor they had years before.
So wait, but you're allowed by law now to go into,
Tell me the therapist who's going to say, I'll do it, even though the other parent won't consent. I can give you, you're gonna know the names, I can give you a bunch of names, no one will do it. Will you?
I was gonna raise your hand for you. I was gonna raise your hand for you.
Yeah, no, I mean, I'm not trying to
I've
put you on
done
the
it,
spot,
no,
but,
I've done it.
you know,
But
I
it
have
all
one now.
depends on how contentious the family actually is. But there is statutory protection that either parent can now take a child to therapy.
Right, and the parenting plan has to say that, in the statute. But,
Oh, it's before, their parenting plan is before,
well, in this case, I mean, we went to trial on it, and this is all post-dissolution, and the mother is still nuts, and is still trying to alienate the kids, and cry on the phone, cry to daddy on the phone, say that you're sick, you don't wanna go, the constant. But when I say, and there's 2 children, so the older daughter has said, Dad, I'd like to go see so-and-so that I saw before, can I go back and talk to her? And so, sure, parental, we at least ask. Mother says no. I ask the therapist, look, mother's saying no, but yes, that's what the statute says, and he really wants to do it. Sorry, no, I won't do it unless both parents agree. And it's been, that motion has been out there for probably 4 months. Well, you gotta go through the order of referral and all of that, so, yeah, so. And the judge in that case, at the end of the period for parent coordination, when mother came back and said, I want to extend it, mother said, I don't wanna do it anymore. Judge said, well, if one parent doesn't wanna do it, then it's not gonna work, so it's not my practice to make them. So, no parent coordination, and it's been a year. And I can't even get, a year since then, and I'm still trying to get into court to deal with the issue of sending the kids back to counseling.
Well, then I don't feel alone.
You didn't realize this was a therapy session.
Yeah,
I have those cases too.
it is a problem, because I've had people ask me to take on cases like that, and I always fall back to the statute that says, only one parent can do it. I think it kind of really sucks that if you're an intact family, you don't need both. And I've always been of the right of, whenever I do anything, I get parents to sign off consents, both whether I need it or
Right,
not, because
right.
it's the way I was taught,
Mhm.
to make sure that I don't get into any trouble in that way. But, I'm trying to think how to get around it for you, but
Yeah,
I don't,
that's, yeah. Do you do those your children?
what?
I thought you were more adult.
No, I do children as
You
young
do
as
children?
5.
Okay.
Cool.
I do socials, guardian, I do it all for you,
I have a question.
sorry.
What percentage of this problem, I'm hearing mine took place 20 years ago, and it seems like there's a significantly increased body of knowledge on this over the last 20 years. But I also experienced the lawyers on the other side inciting my ex, and pushing her to do things that were throwing all the crap at the wall, and I'm writing checks for both sides of the equation. And I hope that these days that the lawyers know a little bit more, but clearly, at least in my situation and others, the lawyers incited much of this.
Well, I would hate to say it, but I think that dynamic is still apparent, that the professional standards.
And I don't mean to
have-
offend you, Joe.
No, I'm not
No.
offended.
I'm
I
aware.
Oh, okay.
Did I just get in here?
Yeah.
I would hope,
It's-
I would hope that it's come down some, but I don't know. I find that I've got one of those now, where you're smiling, you don't.
Initials Joe
Yeah,
JW?
Where I think the other attorney, even if it's not direct, it's indirect because everything is empowering the client. And the number of emails that I could show you where I've said to the other attorney, I refuse to do this because we're just empowering the dysfunction. Parents have to work this out. And I have emails back from him saying, I know you say they have to work it out, but I can't just ignore that he's calling me and making this demand or that demand. And so it does happen, but I would hope that,
Put a parenting coordinator on the case.
Yeah, that it's in certain documents, but you have to have agreement.
Yeah, no, but I'm
Agree
just
to it.
saying, so they stop posturing to the two of you and they start posturing to the parenting
No,
coordinator.
This is a 5-year-old case.
Yeah, they have to have
Paternity was never disputed, but it's 5 years and we've resolved issues. Now it's whether or not the child is allowed to travel internationally. Can, even to go on it this morning, a
A
Disney
cruise?
cruise where you don't
A
have to
cruise?
have a passport. And father won't allow it, because the mother's originally from Russia, so. Just because she's Russian, she may flee to Russia, she would.
Not now, she's not fleeing to Russia.
Eh, tell me. Yeah, but,
Just in answer to your question, I think the answer is the professional standards don't really require lawyers to do a forensic or due diligence their own client's narrative. That's part of the problem. So if your client phones you up and says, the children report that the other parent is doing this and it's saying that, and they're not gonna, if they challenge their own client, the client's gone to somebody else who's more compliant. And it's just hard to imagine the dynamics. And well, before I write the other side, prove it to me first. Try that with a client.
yeah.
They're also gone.
Have you talked about it on our family wizard or on Talking
Yeah.
Parents, or do you have a text, send me the text messages?
Yeah.
I did that this morning.
Yeah, right.
Show me.
Listen, before what happened, there was a change of lawyers, at least in my situation, and there was none of this was taking place. And the lawyer that she went to had a reputation, everybody doing this, and she did exactly what that lawyer said.
So that's unfortunate because we know the damage, right? Like everybody practicing in this area should start with an understanding of the science and the damage to kids. And you can represent your client without, failing to kind of put a box around the behavior. And so I usually just try and get it into a court order and anchor on the court orders prior to a court order, anchor on the legislation, which has certain presumptions built in.
I do have one question,
Sure.
we're talking about court orders. So, just like when you're saying, confidentiality or doing whatever it is, a parent cannot, give a release for confidentiality for what a child says. So when you're talking about your reports and you're talking about this, you can only speak to what the parent is actually doing, you can't actually speak to what the child is actually speaking of, correct?
Yeah.
Well,
Unless
unless-
Canadian laws do,
But the clinician, the lawyer's never gonna meet the child. That's the surest way to get yourself off the case. But clinicians are frequently gonna meet the child because they want to see, maybe the child will explain it differently to them than they do to
But
their
the
own
child,
kid.
no, there's what Andrew is talking about under Florida law. When the child's therapist, the child has the doctor-patient privilege. So you need an attorney ad litem or somebody else be appointed to decide whether or not the privilege should be waived.
Well, again, the answer to that is to ensure that the child's therapist stays within their lane, does not touch relational issues, because they're only gonna make it worse, they're only gonna, because of the therapeutic alliance, they're not gonna challenge the child, like, they're gonna say something like, well, gosh, I'm really sorry you experienced that with your mom, and how does that make you feel? So they're implicitly validating it, they have no idea whether it's true or not. So you can have therapist-patient confidentiality, which can always be overridden, certainly by our courts, in the best interest of the children themselves, if that knowledge is necessary to deal with the family dysfunction. But you can avoid it in the first place by saying individual therapies for individual issues. Any relational issue has to be in an open forum where the, quote, the patient is the family system itself.
Yeah, but you still can't.
Really, so Florida law really
You
hamstrings
cannot,
it.
I mean, I've turned to a judge saying, will you allow me to break it and everything like that, but
It's up
that's.
to judges to decide even, yeah.
Yeah,
No.
see,
Yeah,
that's
you can't-
that's
You cannot
unfortunate.
speak for a
Say-
child.
Well, don't tell me what the child said, but when you came in, when the child came in, what did you see? Yeah, and not been able to get that in.
Yeah, you cannot get a release to speak what a child has said, or
Wow.
done,
Yeah,
or anything.
much tougher.
That's a huge problem. That's a huge problem, which thankfully in most of the jurisdictions I'm familiar with, that isn't a problem. We have to peel back the layers of the onion to get to what's really going on. So,
Right, I'm
Yeah.
sorry, only because
Yeah.
my office is.
yeah, no, I
Yeah.
understand.
So it's 10 after 5.
Yeah, so we should probably wrap this up, but what I can tell people is I'm happy to email this as well as some of the other materials that I mentioned that I think will be very helpful, and that full case study, case start to finish, including my factum when it went to the Court of Appeal, and these detailed orders, and the review proceeding where the court recognizes that it worked when all else had failed, like it was fatal. I had one case, 3 little girls, they were mocking their father, like they would count down at the end of the visits, and they'd scream from upstairs like 15 minutes, like they were mocking the guy, and turned around with a protective separation. So it does work where all else fails, but nonetheless, we're supposed to head it off before it gets to that point.
Right.
And that's the challenge in this very interesting with a capital I, like, area, where we so gratified to have somebody who isn't scared away by the topic. That's it. First responders run toward the fire kind of thing, and that's what we need. Need a whole other generation of lawyers and clinicians, so thank you for your interest in the area.
Thank you for coming.
My
I'm
pleasure.
interested you mentioned AFCC,
Yeah.
which I find to be a great organization.
Yeah.
Yeah.
And PASG, by the way, if you're particularly interested in this, join PASG. We have great next conference coming up in June in Colorado. They've been all over the world. You'll meet some tremendous clinicians from around the world. Here's some really great papers, and you'll get access. There are 1,300 cataloged peer-reviewed journal articles in a database at Vanderbilt that PSG set up on any and every topic imaginable. So lots of benefits from joining. Okay, pleasure
Thank
meeting
you.
everybody.
I wanna thank you all for being here, and Joe and
Oh, sure.
for permitting this. I wanted to add just a couple of things. One, at the onset of your presentation, Brian, which was really so impactful, you mentioned Karen Woodall, and Karen Woodall spoke a week ago. I was on one of the, I was listening to her program, her presentation, and she restated that PA is that the child is the center of PA, that the child needs to be the nexus for understanding what's happening in the home and the PA, not the parents. And that approach, I think, really needs to be better understood. What is the your charting of behaviors, and forgetting about the labels, labeling, and is as I think is a waste of time. You need to demonstrate what is aberrant behaviors, or what are the challenges that one parent may have with the other. And I had the pleasure of having lunch with, and I this is terrible actually dinner, but Dr. Abe from Montreal. Warren Klein, I was right. and he said, hey, see, you won't believe it. And this was with Richard Sauber, by the way. And he says, I got a kid coming in, and what do? I sit him down, and I said, okay, so what was this time? He says, to tell me, what did your mother or what did your father tell you to say? I want to write it down. So the kid does this. And he says, is there anything else? And the kid says, no, that's. Oh, good. I'm so glad. So how you doing? What's going on? And he continues his therapy from a much more relaxed attitude. What did the child do? the child did not betray his parent, who he is allied with, and I think we need to understand, children are allied. Why? They're forced to choose alliance, and everything that they do and say is based on their perception of that alliance. And I think that's really critical to remember. Joel, do you remember Lou Reitenberg? Did you know
I
Lou
don't
Reitenberg?
think so.
Okay, he's a family attorney for many years. He passed away in the last year. But I attended a seminar of his about 5 years ago. He also did consulting with Toby Center for giving me management advice. It was great. But he said, you know what? He said two things that the attorneys might appreciate. One is how judges speak to children is not recorded. That might be an important point for your litigation. I don't know. He also said that invariably children have to be older or sophisticated to lie. So what Abe Warrenklein's approach is to help dispel the myth that children lie, and we give them the outlet to present their parents' lies, and the parents then take the responsibility for the lies that the children have been set up to share. Then the children get to their own truth. So they now you can separate the truths. One of that of sabotaging the child's life, and the other finding hope and future. And for the attorneys, research also shows that every decision will impact a child, either negatively or positively, but up to 6 generations. And the process of litigation is far more impactful than that of the positive attributes, which take time to develop, but and can be. But for those in the very viscerally argued cases, that temperament and those arguments, research has shown to be very destructive on families, not only now, but up to 150 years. So I think that there's a responsibility with respect, as I heard a lot of points being made, as to reform. Change. Why? Because society depends upon it. It's costing us in the loss of graduation rates, it's costing us in higher incarceration rates, and it's costing us in the loss of life and suicides, murders, and these horrific rates of that are really negative observations. So I want to thank you.
Did the bar give you a course number?
Yes, and we have the certificates.
Oh.
Yes, we do. Brian, as a thank you, I can't give you a check enough, but I can give you this book. I would like to give you this book. You mentioned Douglas Darnell, and before he passed away, and I didn't know he was ill, he wrote a testimonial. He said, the book will give the reader a historical background of family court, as well as a direction for the future. It's a must reading for the profession and for the layman facing litigation. The summary of the research is excellent, easy to understand.
Fabulous.
And I'm so grateful because I wrote the book.
Thank you so much. That's great.
Yeah. So thank you all for being here. And again, this was the Toby Center's first effort, and Joel's support in providing CLEs, and we're looking forward to bringing more of the conversations to the how-tos, for what to know. And Brian, we are so blessed to have you in the field, as well as to have you here in Boca.
Thank you.
Thank you.
Thank you. Thank you. Good to see you.
Good to see you.
All right, Andrew, and now when they all leave, all right, you're going to take on the